First, I want to thank Sedgwick Brand Protection, who has been supporting these webinars for this year, and we appreciate it. Thank you very much. Today's program is going to focus on international product safety. And this is really very important. I'm assuming most of you work for companies or advise companies who sell internationally. But even if you're not selling internationally, but thinking about it, this is important information. And even if you're not going to sell internationally, this is important information, because what is going on in Europe and elsewhere is going to help you identify just the trends in product safety in general, which can then go from country to country and be adopted by other countries. Over the years, as we've talked about this subject, we've basically and very generally say that in the US, there are really very few mandatory product safety laws and regulations. CPSC has not adopted that many, even though that was their intention 40 years ago. Or 50 years ago, I guess it is. But we have a lot of product liability litigation, and that litigation does drive safety. It identifies legal requirements and identifies the things the company should think about. And that litigation has also impacted product safety efforts in Europe. In Europe, it's much different. There are lots of product safety regulations, directives, laws, standards, but very little product liability litigation. So when we are selling globally and thinking about this, we really have to be aware of what's going on in all the areas in which we're selling products, so we can do what's necessary to provide a safe and compliant product and minimize risk to the company and, of course, to the consumers. So, for example, a couple of areas where you can have problems is, one, if you sell a product in the US with a certain level of safety and you sell a safer product in Europe because that's required by regulations. And if you then have accidents in the US, the fact that you can make a safer product in Europe is going to be used against you in a US court. So you have to be aware of, if you have different levels of safety in the different areas in which you sell products, you have to be aware of that and be prepared to deal with that if you have to, and defend the adequacy of the product that is less safe. The other area where this is important too is recalls. It is certainly possible, and we have examples of where a product has been recalled in the US, but not in Europe, or possibly in Europe and not in the US or Canada. And these differences create problems and create an argument, certainly in US litigation, that the company doesn't care about safety because they're not treating all consumers wherever they sell the product the same way. And the last thing, which doesn't happen very often, but it can happen, is you can have a European injured party sue you in the US and argue that what you did in Europe was inadequate based on what you do in the US, and that's why they got hurt. So safety is global. You have to think about it that way. And to the extent you're doing different things in different countries, different regions, you have to be prepared to defend the adequacy of what you do in all locations. And if there are differences, be prepared to explain those differences. So with all that said, it's very important for you to understand what your legal requirements are, but also there are things that our speakers will talk about today that will indicate good ideas for product safety and new ways to think about safety, think about risk. And so I think it's just good to know about those things, again, whether you sell products globally or not. So speaking on today's program are three international product safety experts. First, Rod Freeman. Most of you know Rod. He has been active in all the product safety groups around for many years. And he heads up the Cooley law firm International Products Law team. He's based in London, and Rod does everything, both regulatory and the litigation and the recalls and all the things involved in these areas. Second, Ed Turtle. Ed is also based in London, and Ed is working on international compliance and safety issues, regulatory policy, recalls. And third, Emma Bichet is based in Cooley's Brussels office. So because of her location in Brussels, she gets heavily involved in the EU activities that involve product safety and regulatory. She gets involved in product liability litigation and is also involved in recalls also. So I think you're going to enjoy today's presentation. This is going to be pretty quick, and we hope to answer some of your questions. I have a slide at the end for questions that come up afterwards, but I will stop now and turn it over to Rod.
Great, thanks very much, Ken, and hi everyone. It's great to see so many friends and familiar faces and names joining us for this. Always fun to talk about international product safety. As Ken foreshadowed, we've got sort of an action-packed presentation for you in this session. There's a lot we could talk about. What we're going to do is cruise through some topics at a pretty high level, but as Ken has indicated, we're going to have time for questions, and we're happy to sort of do a little bit of a deeper dive on anything that we cover that you think could do with a bit more attention. But we're really happy to have this chance to at least sort of go through and outline those topics, and like I said, follow up with discussions after that. This is our agenda for today. First of all, we're going to sort of get into the helicopter and take a really high level view of the world. Talk about some global trends. What are we seeing in our day-to-day stuff around the world that's sort of driving change and driving the things we're seeing. Emma will talk about some sort of hot topics that are out there at the moment, some of the new developments that we're seeing, and bring you right up to speed with that. We'll dive into a little bit of detail on a couple of topics. Reform of product safety is a big topic in the EU at the moment. We'll bring you up to speed on the proposals to reform quite radically product safety laws in Europe. We're going to talk about circular economy and right to repair and the way that intersects with product safety and why that's important for us. We'll do a deeper dive on product launches and issues that arise internationally, risk assessments and product recalls. And finish off with a bit of a discussion about product liability and consumer rights and how that all intersects with the world of product safety as well. So let's move on and talk about global trends. And the first global trend that I want to talk about is just the fact that the world isn't changing. And there was a time not all that long ago, at least within my memory, where when we thought about product safety regulation, we thought about Europe, we thought about the US, and for most companies, once they got some of those parts of the world sorted from a regulatory point of view, then the rest of the world pretty much fell into place. Those days are long gone. And what we're seeing now, product liability regimes emerging and changing all around the world. This is a trend that's been going on for a decade or so now, but we are now in a world that's a very different place from a regulatory point of view to what it was a number of years ago in terms of the complexity of the regimes and the requirements that exist if you want to access markets all around the world. Within our team, as we're dealing with issues and challenges on a day-to-day basis, we look for hotspots and we monitor hotspots in the world, and we keep our own little list of parts of the world that we are particularly watching in terms of the level of activity, the level of enforcement, the pace of change, etc. Our list keeps changing. Putting together a list for today, certainly there's a lot of activity in the Middle East, Saudi Arabia and the UAE, taking up a lot of our time in terms of regulatory issues for companies. Australia has been a hotspot for a while and is now pretty firmly towards the top of anyone's list in terms of the demands of the product regulatory regime. And the EU, as always, and we'll tell you more about the EU. The UK deserves its own place in the list, particularly after Brexit and the UK Office for Product Safety and Standards forging its own way. And then we have regimes in Asia that are ones to watch and ones to take special care with. South Korea is one, Japan's another, where we're seeing a lot of activity. So these are trends that are happening out there. And as I said, our list of hotspots changes from time to time. But when sort of thinking about product safety internationally, it's worth sort of bearing in mind that there is this very dynamic world out there in terms of the regimes that exist, which is dynamic, but also the way in which the rules are enforced, which does ebb and flow in countries. And we're also seeing just more generally increased regulator activity. So as we're seeing new regimes emerge, we're seeing regulators start to get more and more interventionist and more active. And we are starting to see the fines go up and the penalties go up for companies that breach the rules. And yeah, that's certainly a pattern that we're seeing in the United States, as Ken will be able to tell you in terms of the activities at CPSC level. But we're seeing similar things in other parts of the world, where the regulators are starting to wake up to the fact that there's not much point having strict regulations if they're not going to be enforced. And so companies are being hit quite hard increasingly around the world for being reckless with the rules, or being careless, or just being unlucky in terms of compliance. Alongside that, and I think one drives the other, we're also seeing increased international cooperation and a lot of change around policy. On the international cooperation front, we're seeing this happen at a number of levels, where the regulators talk to each other, they share best practices, they share experiences, and they try to learn from each other. We see that happening, for example, within the OECD, where there's a working party on product safety that has grown in size and activity very much in the last few years. I sit on that working party as an industry observer and participant. But most importantly, I get to hear the governments of the world sit around a big table twice a year in Paris and talk about product safety policy. And I can tell you it's a very active working group. The CPSC is always there and always very vocal. The European Commission's always there, and 50 or 60 other countries represented in the room sharing best practices. Similar groups operate on a smaller scale within the United Nations and within ASEAN. So at a regional basis, we're seeing these kinds of things emerge. The Organisation of American States is getting organised around product safety. And then we have organisations such as ICFSO, which bring stakeholders together in the interests of international cooperation. So we're seeing a coming together in some respects of product safety regulation. And that's also important when it comes to policy reform, because as we'll speak about a bit more shortly, there's a lot changing, a lot of policy change happening just at the moment around the world, and we've got a lot more to say about that. One other global trend I just want to sort of talk about is the sort of expanding concept of product safety, product compliance. It certainly used to be the case, again, where we'd think about sort of producer responsibility in two buckets. There's product liability and product safety, and they're both sort of quite distinct areas, but obviously with some degree of overlap. So when companies were making products, they'd sort of have people that worried about product safety regulation and compliance, maybe some other people that worried about product liability, and that sort of covered the field in this area. That's changing now, because what we're starting to see are considerations such as around sustainability and the circular economy start to come into the product compliance space. So now you can no longer safely distinguish product safety regulation from sustainability regulation. They're part of the same regimes, and companies, when designing products, marketing products, making claims about their products, need to think about these in the one breath. Similarly, around data security and privacy, particularly as products become more complex and driven by technology, then considerations, rules and regulations and standards around data security start to come into the product safety world and the product liability world, and need to be thought about at the same time. So companies need to broaden the way they think about product compliance and not think of these as separate buckets, but these all do come together as one bucket of risk for companies that make products and sell products around the world. Emma, do you want to talk a bit more about some of the hot topics?
Yeah, thanks very much. So just looking at, we had a little brainstorm in the team to come up with a list of hot topics. And Rod has already touched on quite a lot of these actually when going through the trends. So one of them as Rod just said, so this expanding concept of what we understand by safety. We're seeing increasingly blurring of product safety rules with sustainability and environmental considerations. We see this a lot in chemical assessments, where we're looking both at the health and also the environmental impact of substances. Also, when we think about safety in the context of health and safety, what we understand by health is also changing. So we're seeing this when the general product safety rules are being updated, that impact on health is also understood to mean impact on mental health, things like depression, loss of sleep, all coming into the safety assessment of products. Elsewhere around the world, Rod mentioned a few hotspots. So in Saudi Arabia, what we're seeing is that safety issues are being treated more and more on a par with quality issues. So that's another way that this fundamental concept of safety is being gradually expanded. The second one there is extended producer responsibility and ongoing post-sale obligations. So this is something that's more and more of a trend, especially in Europe, that, you know, the buck doesn't end when you put the product on the market, that you do have more and more post-sale obligations. And that's something we'll talk about a little bit later when we talk about right to repair. Product recall effectiveness, that's what Rod told us. Regulators are scrutinizing more and more closely. Product recalls are becoming increasingly interventionist in terms of enforcement. And finally, roles and responsibilities of online marketplaces and online sellers. This is, in many ways, it's the legislation catching up with the realities of the supply chain. More and more products are being bought online. Especially in Europe, online sales are seen as a particular challenge in terms of enforcement, particularly because we have decentralized enforcement. So there can be some holes, some gaps, and there's a lot of new legislation coming out to try to fill those gaps and make it clear who's responsible when products are bought online. This next slide, I presented at a different conference and got the comment at the end that I had given someone a panic attack. So hopefully that's not the impact. It's certainly not the intention. The idea is just to show that there's really a lot going on at the moment in Europe. We've never seen so much legislation coming out all at the one time. The Parliament's calling it the fourth industrial revolution. And so it's just, we're keeping track of it, but there is a lot going on. I'm not going to talk about everything on this slide, but just to draw out some general themes here. One is the drive towards sustainability of products, and it's the European Commission really trying to use product safety law as a tool to meet the general climate change obligations that Europe has signed up to. So things like zero pollution, we're seeing that concretely in the proposed reforms to the chemicals regime, which is REACH, and also to ROS, which is about chemical content of electronic products. We're also seeing that in the packaging revisions that are being proposed, circular economy, more and more, all part of this general green transition, they call it in Europe. The second main theme here is the digital transition. So that's updating the rules to take account of the fact that products are different now. So, you know, we have AI-enabled products, we have the Internet of Things, also the new sales techniques that are available. We talked a little bit about online sales already. And new possibilities for regulators. So legislation is being updated, and we're seeing new initiatives like digital labels, which wouldn't have been an option before a couple of years ago. So that, then just looking in specifically on the digital transition, the fact that new tech is really in the spotlight in Europe at the moment. So one big thing that's all over the news, and probably you've heard of it as well, is the AI Act. So that was proposed by the European Commission in April of 2021. And currently it's being negotiated between the European Parliament and the EU member states that sit in the Council. What the Commission has proposed is a risk-based approach to AI systems, an attempt to categorise the level of risk posed by AI systems in terms of harm to health and safety, and also potential adverse impacts on fundamental rights. Really what we're seeing with that legislation are some very familiar concepts for product safety lawyers, things like conformity assessment that we're very used to dealing with in product regulation. In the UK, there's been a lot of political statements from the UK saying that they don't want to follow the EU approach, that they want to be pro-innovation and have less regulation. It remains to be seen what approach the UK is going to take here with AI. We got in May, and that's linked on the slide, there was a report from the UK's Office for Product Safety and Standards, that's the OPSS, and that's identifying the challenges and benefits associated with AI. So we have to see from that what kind of regulation will be on the table in the UK. Another big development in terms of new tech, and something that we're seeing more and more, is cybersecurity. So Rod touched on that before as one of the trends. The EU's just adopted rules for internet connected radio equipment with cybersecurity standards. And there's also more broader general initiatives to adopt some sort of horizontal legislation on cybersecurity in the EU. So these are all things that are going on thanks to new tech products. Then on reform of consumer product safety, that's another big topic in the EU, and I'll pass over to Ed to talk a little bit more about that.
Thanks very much, Emma. So I want to talk about a major proposal for reform of the product safety framework in the EU, and one which Emma's already alluded to. But before I take a look at what's being proposed, I just want to anchor things briefly with a sort of reminder of what the EU product safety framework looks like at the moment. And I'm going to keep that pretty brief because I know that many of you will be familiar with how this works. Essentially, you have sort of three parts to the existing framework. So first, you have the comprehensive regimes covering products such as medicines and food. And then secondly, you have the specific sector regimes, for example, those covering radio equipment, machinery, or toys. And generally, those are sort of as shorthand thought of as the CE marking regimes. And thirdly, you have the General Product Safety Directive. And that applies to all other products which don't fall within those sector regimes and are therefore wholly governed by the General Product Safety Directive. But it also applies to products covered by the sector regimes to the extent that there are no specific provisions with the same objective within those sector regimes. So that's the framework, and that means that the majority of products sold in the EU are therefore governed either by a hybrid of the sector regimes and the General Product Safety Directive, or wholly by the General Product Safety Directive. And it's this broadly applicable General Product Safety Directive that the EU is currently looking at tweaking, and those are the reforms I'd like to sort of focus on today. So Emma, I've got the slide up, thank you, you've already preempted my move. This slide sets out some of the sort of big changes in the proposed new General Product Safety Regulation. I want to just pick up on a few of these. This is a topic that could bear sort of a whole presentation, I think, but I'm just going to cherry pick some of the sort of highlights. So first, the proposal to align requirements for non-harmonized products with those of existing harmonized or CE marked products. I think that sounds like a relatively benign change, but in practice, it's a big one, meaning that just like for CE marked products, non-harmonized products will need to meet the same sort of conformity requirements. They'll need a technical file, risk assessment, more detailed labeling, instructions, warnings than are currently required. And that's quite a significant amount of work for companies that have a large inventory of non-harmonized products. Secondly, it proposes mandatory incident reporting. This is a bit of a headline grabber. As many of you know, there's generally only a requirement in the EU to report incidents at the moment if the product involved poses a safety risk, and that's normally established by an investigation and risk assessment. The Commission's proposal would make it mandatory to report any accident you're notified to the authorities. And the proposed timeframe in their draft is just 48 hours. There are sort of a lot of unanswered questions. I'm sure you already have thinking of some about how that would work in practice. So sort of things like what would constitute an accident? Is a user error included? Failure to follow instructions? Or does it need to be a product-related fault? Is an injury required, or is any sort of accident leading to property damage or even no damage at all notifiable? How is causation established? Who works out whether it was the product or something else which caused the incident, especially in the 48-hour time frame? And when does the clock start to run for the purposes of making that notification within 2 days? So does knowledge arise at first notification of the accident, or should knowledge only come about once an investigation has been carried out and completed? These are the practicalities that are being threshed out at the moment between the EU institutions. And we don't have a landing point currently, but we do know we'll get one later this year. So this is an area to watch. Thirdly, the GPSR contains new proposals for recalls. Those include stricter requirements for advertising recalls, which move the EU system closer to what we see in the US, obligations to disseminate recall notices more visibly, directly contact affected consumers wherever possible. And alongside that, there are quite strict requirements in the proposal for the content of notices in the context of recalls, with bans on certain terms like voluntary or precautionary, and also on saying that there have been no reported incidents. Coupled with that, there'll be new provisions on remedies, which sort of generally prioritize the easiest outcomes for consumers. So that's quite a package of changes, and we'll have time to pick up on some of the others in the Q&A session. So with that, I will hand back over, I think, to Emma. Are you on the next one? Yeah.
Yeah, so just picking up on the circular economy and the right to repair that we discussed a little bit earlier. These are big topics in Europe at the moment, big topics everywhere. The European Commission has announced that there is a right to repair for European consumers. It's really very supportive of this concept because it sees this right to repair as a way to facilitate a European transition towards a fully circular economy. The idea is that it's better to repair products than throw them away or even than recycle them. We also saw our US colleagues were following this week. The New York State Legislature passed the Fair Repair Act, so obviously it's being picked up on elsewhere around the world. So what do we mean by the right to repair? Well, it can refer to quite a few different things. So we can be talking about the consumer's right to repair during the periods covered by the legal guarantee, so during the warranty protection. That's probably more familiar for everyone. Then there's this expansion of the right to repair even after the legal guarantee has expired. So ongoing supply obligations for spare parts, this kind of thing. Then thirdly, we have a right for consumers and also for third-party service providers to repair products for themselves. So this idea that repair shouldn't be anymore only for the manufacturer, and that should be something that is open to the consumer, that's easy for them or for third parties. So in order to support this idea of a right to repair, what we're seeing in Europe and elsewhere around the world is an increase in legal measures, which are covering requirements to design products in a way that facilitates repair. So, you know, eco-design is a big thing in Europe at the moment. The idea that products, that the sustainability credentials of products basically are predominantly decided when they're designed. So they should be designed in a way that they can be easily repaired. We're seeing more and more obligations on manufacturers to repair faulty products, and more information requirements. So this is something that's come up in the EU eco-design proposal, that manufacturers can be obliged to provide instructions on how to repair their products. And that's from day one, and something that has to be made widely available, both to the user and also to third parties and to authorities. And then, as we've talked about, there's obligations to make sure that spare parts will remain available, so that even after the product's been placed on the market, even after the product no longer in production, there might still be ongoing obligations to supply spare parts. And that's something we're already seeing. In Spain, for example, there's a 10-year time frame where the manufacturer will have to provide spare parts. And then moving on to speak a little bit about the circular economy. So the right to repair is a big part of the circular economy. And that's something that's a huge theme in Europe. It's spoken about almost every day. We had the circular economy package of legislative proposals came out in March, and there's a second package that we're waiting for at the moment, which is going to come out in July. We saw this week the Parliament and Council reached a political agreement on having a common charger in Europe, which is a big part of circular economy as well, of waste reduction. The changing role of the CE mark. So we've already talked a little bit about that, this idea that safety, or that the European CE certification is no longer just about safety, it's also about the sustainability credentials of the product. And expansion of EU eco-design. So that's something that got proposed in the circular economy package in March. And we're expecting that to have a really big impact on the products industry, because right now eco-design is something that applies to energy-related products in Europe. So things like white goods, laptops, tablets. But what the Commission is proposing is to expand it to basically any potential group of products, starting off with the ones that have a high environmental impact. So they want to start off with things like textiles and intermediary products like aluminium and steel, and impose these eco-design obligations on those products as well. The chemicals rules, I talked a little bit about that already, but we're seeing circular economy considerations also in the way that chemical assessments are done. The different impacts that we have to take account of now is no longer just about safety. And lastly, greenwashing and sustainability claims. So that's something, obviously, sustainability is also a very powerful marketing tool for companies. So there's a drive to make sure that legislation is in place to stop that being abused. That when companies are making claims like a product is sustainable, that they have something to back it up. And in Europe, there's just been some new proposals around that, trying to regulate what can be said and what can't be said about products. And then I'll pass over to Rod, who's going to speak about product launches, risk assessments, and product recalls.
Thanks very much, Emma. And just a reminder to everyone to feel free to sort of fire your questions in while we're talking. We'll also have time at the end. Ken, correct me if I'm wrong, but I think do people use the chat function to get their questions in? Is that?
That's correct. That's correct.
Yes. Okay. So feel free to sort of raise your questions as we're speaking. But now just a sort of a few words on product launches, risk assessments, and product recalls for international companies. The first topic I want to touch on is just around risk assessments and product recalls. Just to mention, in case you weren't aware, that in the EU we have a very sort of fixed and defined methodology, risk assessment methodology that companies are expected to use if they have reason to believe that they may have marketed an unsafe product. So there really isn't any other jurisdiction in the world that operates quite in the same way in this regard. But certainly for consumer products, if a manufacturer discovers that a product they put out there presents a risk they hadn't expected, hadn't properly anticipated, then one of the first things the company really should be doing is pulling out this risk assessment methodology and applying it to try to get some sort of categorization of the risk. What I'm showing you here is just the last section of the risk assessment. It goes for many, many pages, in fact, and it is quite a detailed and prescribed methodology that actually is very good for some types of risks, a very useful tool for manufacturers to use. For some types of risks, it's not so great. But what we can say is that the regulators around Europe take this pretty seriously, and if you don't do the risk assessment to assess your own risk, the regulators will do it for you. They may do it for you anyway, but it's always important for companies to get sort of a head start in using this methodology when confronted with an unexpected risk, especially involving a consumer product. So that's something that's quite peculiar to the European regime, but does have some leverage in other parts of the world as well. So as I said, it's a tool that in many respects is very helpful for companies when dealing with an unexpected problem.
Rod, can I ask a question?
Please do, Ken.
What would you think about using this methodology as you design products? Because obviously we're doing risk assessment as we design products. Do you think this has any usefulness in your thinking about risk?
Yeah, my view on that is that it shouldn't be used for pre-market risk assessments. It's not designed for that. So it's not intended to help you decide if you should make a design change to a product. There's a different sort of set of considerations that you get to make if you're pre-marketing. When you're dealing with a situation with a product that's already out there, you're kind of dealing with a different set of parameters. Obviously, most risk assessments in the world have the same basic elements. You're looking at the seriousness of the potential outcome, you're looking at the probability of that serious outcome arising, and you're finding a way to measure those. So the basic principles that underpin this are useful for pre-market risk assessments, but certainly I wouldn't encourage use of this methodology as such for pre-market risk assessments for those reasons. Something else to draw to your attention is the emergence of a couple of important codes of practice that have been developed and published under the supervision of the UK Office of Product Safety and Standards. These are quite important because, again, there aren't too many of these that exist around the world, sponsored at a government level. But we now have two in the UK. The second of them was only published a few weeks ago. The first one has been around for a while, although a new version of it was published just a few weeks ago as well. I actually sat on the steering committee that drafted both of these, so I had a bit of an inside run into how it got put together. That's not to say I'm 100% happy with all of the outcome, but what is important is that the UK regulator takes these documents pretty seriously. So when supervising companies, when dealing with regulatory issues, they will say to companies, and I've seen this happen, they'll ask companies to account for themselves by reference to what's in these codes of practice. The one on product recalls, the older one, the title's a little bit misleading because only about 1/3 of it deals with how to do product recalls. The other 2/3 of it deal with what companies should be doing to prepare themselves to do product recalls. And that's important to understand because when I'm saying the regulators can come to you and say, show me how you comply with PAS 7100, they're not asking you to tell them about product recalls you've done. They're asking you to tell them how you have prepared yourself to do a recall if you need to do one. So most of it is about preparation and proactivity rather than reactivity. There's plenty in there about reactivity as well, but it's an important document that the regulator takes pretty seriously. The newer one, PAS 7050, is the sister document that focuses on what a company is expected to do before placing a product on the market in the first place. Obviously, the two documents go very much hand in hand, and there's a fair bit of overlap between the two. But again, you can expect regulators, as this thing rolls out, the UK government is running out training sessions at the moment on this, and they're going to expect companies to be able to demonstrate that they comply with the principles here and the points. The truth is that most reputable, responsible international companies are doing the stuff that's required by the new code of practice anyway, the PAS 7050. So a lot of it is just sort of common sense and regulatory compliance anyway. But as I've said, if there are gaps in systems, and especially when things go wrong, then these are documents the UK government will use to hold companies to account. And the practical reality is if you're an international company making products for the world, some of those products coming into the UK, then you need to start looking at whether your sort of central processes and systems are up to scratch when held against the spotlight of these codes of practice. I think we can expect these codes of practice to start to become influential worldwide, either with some other parts of the world actually using them as they are, or at least modelling their own codes of practice based on this. Another area of focus at the moment is product recall effectiveness. I just want to make you aware of this as well, that there's, I see this in the discussions at OECD and within the European Commission, and I'm involved in those discussions, that there's a lot of focus at the moment on product recall effectiveness, a real sense amongst the policymakers and the regulators that product recalls are just not successful enough. We're not getting enough products back. We're not doing enough to remove the risk from consumers when product recalls exist. So there's a lot of empirical work being done, and we're starting to see some policy change intended to ensure that companies do a better job of their recalls, quite frankly. So we're listing a couple of quite specific things. One is regulators are changing their attitude. When regulators are monitoring recalls, we see this very much in parts of the world, such as Australia and in some parts of Europe. The regulators are asking for regular reports on success rates, and if they're not happy, they will ask the company to do more, or they'll ask the company to do things again, and if they're not happy, they'll ask them to do it again. So we have started to see in recent months quite extraordinary requests from some regulators internationally of companies where the regulator hasn't been happy with the consumer response to particular product recalls. So this is a real thing now for companies that find themselves having to do recalls around the world, and it's going to continue. Ed referred to the reforms to the General Product Safety Regulation. You see some of this embedded in that as well. So important to watch out for that as well. Ed, do you want to just talk to us a bit about product liability and consumer rights?
Yes, thanks, Rod. So I'd like to just end with a short update on some significant changes in the product liability and consumer rights space. As Rod's already mentioned, we increasingly see overlap between product safety, product liability, and consumer rights, both in the wake of product safety issues, but also in the minds of regulators and policymakers who are no longer treating these as distinct areas of the law. So the big news is that there's a proposal to revise the EU's Product Liability Directive, and that's the EU's main regime for product liability claims, which establishes strict liability for producers. In terms of where things stand at the moment, this is a bit of an earlier stage than the General Product Safety Regulation that I spoke about. So the Commission has started initial public consultation, but the legislative proposal hasn't yet been published. We expect that later this year. So what we can do at this stage, though, is give you a few pointers about sort of key issues we're expecting. We know quite a bit about the direction of travel and what we're likely to see. So the first sort of key issue I wanted to highlight was changes that we expect for making it easier for consumers to bring claims. So we expect to see changes like relaxing time limits and removing the current minimum threshold. There's currently a minimum threshold of €500 for damage to property claims, and removing that will make damage to consumer products recoverable. Also expect to see a reversal of the burden of proof in some instances, meaning the manufacturer would have to prove that the product was not defective rather than the other way around as it is currently, and allowing courts to infer defect and causation in certain circumstances. And one of the circumstances which is being mooted is following on from a recall. Secondly, the continued focus on new technologies. They are looking at overhauling the existing product liability directive in light of new technologies. They want to expand the definition of products to cover intangible products such as software, and also think about what effect lifetime software updates have on products and on liability and allocation of liability. Secondly, and sort of coupled to that, they're looking at extending the range of damages to non-material damages, such as data loss and privacy infringements, as well as mental health effects and the sort of broader concepts around that Emma touched on in the regulatory side of things. Finally, I just wanted to mention as well that there's an awareness that the circular economy proposals that Emma's been talking about on the regulatory side, the reforms that are coming through there, will also have an effect on the liability side. The EU is really keen to promote sort of everything it can do to move Europe towards a circular economy, but there are legitimate concerns around safety and liability with requiring consumers' sort of products to last longer, and also introducing a right to repair. So we should see some consideration of how those are dealt with in the proposal that we expect later this year. It's also worth saying this sort of focus here is on Europe, but the Commission has explicitly said it wants to take the lead here when it comes to liability for new technologies in particular, and expects the sort of direction it takes to have an impact in the rest of the world. And we think that's not unreasonable because the underlying issues here are ones that are being dealt with by other regulators. There are sort of issues of new technologies, the blurring of lines between tangible and intangible products, and the growth of e-commerce, also something that's expected to be tackled, and climate change and more environmentally friendly products. So it is likely that the EU is going to be amongst the first movers on some of these issues, and we expect to see other jurisdictions looking to what their example when they seek to address these issues themselves.
Ed, can I jump in and ask a question?
Yeah.
You know, what drives US product liability litigation a lot are the availability of contingent fees for plaintiffs' lawyers, the availability of high damages or punitive damages, and then third, the ability to file class actions on behalf of a variety of consumers. Is any of that in the product liability directive, or what is the trend there on those issues?
It's a great question, and it's incredibly timely certainly on the class actions front, Ken, because on the next slide, Emma, if we could turn to the next slide, maybe. There have been some reforms in the consumer rights space, which are looking at bringing in reforms around collective or group actions in the EU. There's been a move towards a more US-style system, but not yet a sort of full adoption of a US-style system with punitive damages and things. Maybe I can just speak to some of those points, Ken, in the context of this slide. So the second bullet point there addresses this new collective redress mechanism that will enable sort of group actions on behalf of consumers for breaches of a whole range of EU laws, including consumer rights, product liability, and product safety laws. There are some existing mechanisms in individual member states, but this is bringing a sort of harmonized system across the EU. And these actions can either be brought in one member state or as cross-border actions across multiple member states. Redress will include injunctions and compensation, a requirement to carry out product repair, replacement, or refund. They don't go as far, as I say, as sort of introducing US-style class actions. And the European institutions have deliberately put sort of limits on the powers to try to avoid a full adoption of a sort of more class action style system. Those limits include the fact that these actions can only be brought by qualified entities, and critically, that doesn't include law firms. So these will be more sort of NGO style consumer bodies bringing these actions. And the second point is there won't be punitive damages available. So I think the reforms move us much closer to what we see in the US, but not a full adoption of that approach. It's also worth mentioning a couple of other reforms in the consumer rights space, which are picked up on that slide. The new Sale of Goods Directive, many of you will be aware, came into force at the beginning of this year. The EU has always had a particularly sort of consumer-friendly approach in this space, but this increases consumer rights considerably, giving consumers a minimum 2-year guarantee for a remedy for defective products, with the burden of proof on the trader for the first year to prove that a product wasn't defective if it goes wrong. And in practice, that creates a sort of statutory warranty. And interestingly, they've also brought in those protections for digital content for the first time, digital content and services. And alongside that, this same legislation also sets minimum periods for software updates. And that can vary depending on the type of product, but generally it sits at around a minimum of around 2 years. The last sort of reform on this slide, I won't speak to in much detail. I'm conscious of leaving time for questions, and Emma's already mentioned it in detail, but that new consumer agenda will see further consumer reforms in the next few years, including in particular those reforms that are designed to deal with increasing consumer information on environmental issues and preventing sort of greenwashing. But with that, I think I'm should probably stop so that we have some time left for questions. And I'll hand it back over to you, Ken, so you can handle those.
And I don't know if anyone has sort of put through questions in writing. We can't see them, Ken, if anyone has at our end, but if they've gone in to the host, then we're happy to answer those, or if anyone has any other questions.
Yeah, well, Rod, you received several questions that were submitted before the program, so if you can deal with those now, that would be good.
Okay, so let's sort of deal with one of them. There was an excellent question that came in about the sort of interaction between the European general product safety sort of regulations and the codes of practice that I mentioned in the UK, and sort of what are the expectations of a manufacturer in terms of compliance with provisions such as that. I mean, the reality is these requirements sit alongside each other, and in some respects operate in a different way. I mean, obviously the priority is always with the laws and regulations over any guidance. If there's a conflict, and in Europe, we have our General Product Safety Directive and the sector directives that sit alongside those. When the General Product Safety Directive is replaced by the new General Product Safety Regulation, then that will define the expectations for manufacturers of consumer products to the extent that those provisions apply. The codes of practice are not intended to be inconsistent with the law. As I mentioned, I was on the drafting committee, and there were certainly many times where I asked them to roll back some of the proposals because I felt it was inconsistent with what the law required. But there's still plenty in the codes of practice that go beyond what is strictly required by the law. But they do set parameters for what a regulator expects a responsible company will be doing to ensure that nothing goes wrong. So whilst you can't be prosecuted for breach of the code of practice per se, that there are circumstances in which the code of practice is considered to be defining the expectations where the law is a little bit vague. So it becomes challenging for companies, and challenging when the UK is just one country, just one market. The regulator is trying to define the expectations of an international manufacturer if they want to send products to the UK. But in order to meet those requirements, it involves quite systemic changes with the way that the company manufactures its products. So it's an interesting challenge.
We do have about 4 questions in here, Rod. I'm not sure if I assume you can see them.
Well, we can't, Ken. So maybe if you want to read them out, or
yeah. Okay. What is the current status of passage of GPSR, and are amendments to clarify it's still under consideration?
To that one,
go for it.
Yeah. So the draft legislation was published just about 11 months ago in June last year, and followed a period of scheduled feedback, a public consultation period, which closed at the end of October. And that legislation is now working its way through the ordinary procedure in the European institutions. So the Commission and Parliament, Council are negotiating out the sort of final details of the proposal. We haven't yet seen a final agreed draft, and we expect that by the end of the year. And in terms of sort of likely landing points for when it comes into force and when it will sort of apply for businesses across the EU. Those provisions are still being argued over as well, but we think it's likely that it'll come into force late this year or early next year. That's the sort of earliest time frame, and then an enforcement date of end of 2023 to early 2024 is looking sort of plausible at this stage. And
just on sort of immediate next steps, both the Commission and both the European Council and the Parliament have indicated that they expect to publish their positions in July next month. It was going to be this month. They've announced a delay. So that's the next critical stage in the process, because once we see what the Parliament and Council think, if they are very much aligned with the Commission proposal, then there'd be a higher expectation that that we're starting to see what the final version of this is going to look like. If there are significant divergences, then there's some sort of negotiation to be done before a final version is reached. So we're sort of holding our breath till next month at the moment to see what where the Parliament and the Council land on what they think of the Commission's drafts. There have been hundreds of amendments proposed through this process. So there's still not a whole lot of clarity on where we're going to land on some of the really critical points in it.
Okay, I'm going to combine a couple of questions here, hopefully successfully. GPSR includes repaired and refurbished products. And of course, the question of whether the OEM provided an unsafe product or whether the repairer screwed up the product and made it unsafe themselves. So do OEMs under GPSR have a responsibility for consumer repaired products? And then let me just look at that last slide here. How can you reconcile the right to repair with product safety when it can potentially diminish the safety of a product?
Who wants that?
Whoever wants to take that.
Those are excellent questions, and that's things that are coming up for our clients all the time, especially in the context of the batteries rules, for example. If you're having users with wearable devices that are replacing their own batteries or that are trying to repair their own batteries, and that can cause safety issues in itself. And these are things like Ed mentioned when he was talking about product liability, that there's not clear, bright lines on where the responsibility of the manufacturer ends and where the responsibility of the user kicks in. I think the idea behind the right to repair as well, products should be designed so that they can be repaired safely to avoid this kind of problem. But of course, this is the kind of issue that is going to come up more and more. I think it's a great question, and it's just something that our clients are really concerned about.
Oh, go ahead, Rod.
I was going to say, so in theory, the OEM should be simply responsible for the safety of its product when it places it on the market, and then a repairer should be responsible for a defective repair. In the mind of a policymaker or somebody drafting the legislation, they see this as all very straightforward. But we all know that in the real world, where this becomes very complicated and there are evidentiary problems and it all becomes very uncertain. And add to that the point that Emma made, that it starts to bring in the responsibility of an OEM to design a product to be safely repairable. So in reality, the lines get very blurred as to who's going to carry the can if something goes wrong here.
Well, and I can tell you from the US standpoint, certainly when we sell products, we expect consumers to try to repair them. And to the extent that our instructions contain repair instructions, they better be accurate and clear. And if they're not, then you basically could be charged with having defective instructions on the repair. So here now they've just formalized the requirement to give the right to repair. So it makes it even more formal that we provide adequate repair instructions. And I've had problems when there are certain products like motorcycles, we do not want people to repair certain parts of a motorcycle, and we struggle with trying to figure out how to, we don't want to tell them how to do it because we don't want them to do it. But now these laws are going to come out that require us to tell them, so we better do it adequately. So that is foreseeable that they will repair the products, and if we don't have adequate instructions, then we have a problem here. Let me just see. Rod, how does someone get involved in standards development in the EU? A US person, can they do that, and how do you do it?
There are various sort of standards organizations. The standards sort of emanate from a number of sort of bodies, depending on the subject matter and the like. Many European standards start as international standards. But if we're talking about standards that are sort of sort of originating in Europe, then there certainly are opportunities. Yes, certainly in Europe, I think more than the US, there's an emphasis on the role of the trade associations rather than individual companies. Often the route to involvement in standards development is through sort of trade association involvement, at least in many industries. Yeah, it is an area that is to some degrees sort of can be a little bit impenetrable in Europe, just as it is in the United States, certainly in some areas.
Okay, why don't we do that in light of the time? Emma, can you go to the next slide here? I'll have one more slide that you'll want to see. But we have webinars coming up September, October, November. Those are the subjects we're going to deal with. We thank you for attending today's session. Next slide. We are posting a recording of this webinar and the slides on the SPSP website. Here are, and any other material if whatever, but the slides, the Cooley slides have great links to the various documents. And today, almost the best thing we can do is just highlight what's new, what you should be interested in, and how to find out more information on it. I think we'll try next year to do some more detailed, in-depth programs and post them on the website where we can get into great detail. And if you're interested in, how to do a European risk assessment, we can provide a separate, training session on something like that. Now, a question came in about using these slides in internal training. I would say, well, they're going to be available on the website. They're available to anyone, so you can certainly direct your employees to them. I guess I'd be careful because the slides by themselves may not make a whole lot of sense without the expert commentary we've heard today. So you want to be careful about that, but certainly that to the extent that they are identifying additional documents and directives and codes of conduct, certainly that is useful information for you. So this information can be useful in internal training. Be careful about how you use them so you're not misleading people and giving them inadequate information. But the 3 email addresses are right there. So if you want to talk to any of our 3 speakers about either using any of their slides or having them help you on some of your internal training, certainly that's appropriate. I think last slide, I think that's all I want to talk about. We're a little bit over. We appreciate your attendance today. Thank you to Rod, Emma, and Ed. Great job. And if hopefully you still have questions. If you don't have questions still, then you haven't been listening. But so we don't promise to answer everything you can ask or give you all the information in all these areas. This subject matter kind of explodes my brain to the extent of if I'm advising somebody on selling in 50 countries, my mind is going to wander a bit and call Rod because it is way too complex these days. And as you can tell, it's not getting any better. So again, thank you all very much for attending. Feel free to tell your employees where they can find a recording of this and the slides. And hopefully it'll get you thinking about things that you can do to prepare yourself for this new product safety regime that is coming about. Thank you all, and we'll see you in September.
Thank you, Rod and the Cooley team.
Thank you.
Thank you.
Thank you.
Thank you very much.
Okay, I think we are. Have we stopped recording?